right, we are going to hop back in on our car forms updates. Last week we covered the BRBC form, which is the broker representation, the buyer representation and broker compensation form. It was like, what's the new acronym stand for? Buyer representation and broker compensation form. There's a few other forms that are tied into that one. So we're going to cover those first, and then we'll sprawl out from there on the forms that were changed. So the first one is the anticipated broker compensation disclosure. So as part of the BRBC form, you are required either to mark the box either at time of showing or before offer is made that you're going to disclose the compensation being made, being offered by the listing agent on or the seller on a property to you as the agent. So there's a form for that, or you can provide them with copies of the buyer reports from your MLS system, because most of those now on the buyer reports show the compensation being earned. It was something that happened last year. You'll see it's on Zillow, Realtor.com, everywhere you can see what the compensation is now. It's for full disclosure. So, but there's this other form you can use. So if you don't want to print up each page or the reports for those properties and give to them at time of showing, then you could provide them with this list as well and have them sign off on it. And again, it depends on what you put on that buyer representation and broker compensation agreement, whether this needs to be done at time of showing or at time of offer. You're going to fill in the buyer's broker here. Is a real estate licensee providing services to buyer one, buyer two, their names would go there. Broker anticipates receiving a compensation from the seller or seller's broker, or you would mark here for other if there was some other random way you were going to get compensated. If buyer purchases any property identified below, compensation will be paid pursuant to the MLS offer, a cooperating broker compensation agreement form, CBC, or other source specified in the column below. Buyer is aware that any commission paid by the seller directly or indirectly through seller's broker affects the seller's total costs and expenses for the transaction and may impact the price seller is willing to accept. If for a specified property, broker has provided if for a specified property, broker has provided buyer with a copy of the document from the MLS that identifies the compensation offered to the cooperating broker for a listed property, that property may but does not need to be listed below. See, there's your opt-out if you're going to provide that report. Broker independently through escrow will disclose the final compensation broker receives from anyone other than the buyer. Buyer's brokerage firm with the license number. Your name goes on the next line with your license number and your date. You're going to sign that, hey, I'm disclosing this information to you. Buyer's going to sign this middle box here. Buyer acknowledges that buyer has read, understand, and received a copy of this anticipated broker compensation disclosure. By initialing in the box below, buyer acknowledges being advised of the broker's anticipated compensation for the properties identified or property identified. Okay, buyer's going to sign there. This section to be filled out when the property is being shown or when an offer is being made. You're going to put in the property address, the date that you first showed or made offer, the compensation being offered. It gives you an option for a percent or a flat rate, and whether that's being offered by the MLS, the CBC, or X, right? So maybe if it was a for sale by owner or something like that, it might be this third box down here that the compensation is being offered by. Your buyer's going to initial each section here. Keep in mind that there's only 2 buyer signature lines. So if you have more than 2 buyers, you need to use the ASA form, the additional signature addendum to this every time it gets signed, where the 3rd, 4th, 5th, 6th buyer is going to sign that ASA form. Okay. This section to be completed upon close of escrow when the final compensation is determined, final compensation from persons other than buyer, right? So the property located at blank as follows. From seller's broker in the amount of blank, and if applicable, blank from the amount of, right? So it gives you lots of lines to fill in. So if you're getting some from the seller and some from something else, you would put it in there, or just the amount from the seller. Buyer's brokerage firm, you're going to put that information there, license number, my name or your name, your license number, date. Buyers' initials below are not required, but can be used as evidence that buyers have been notified of the final compensation. You're going to initial there. So this makes it really easy that you can fill out this form up here anytime you go show properties. And then when you go to complete this is going to be upon the close of escrow. So you're going to finish this last section here at the final signing. So you probably want to send it over to title with the final closing documents to be signed so that everything's taken care of. Title will shoot it back over to you. Super simple form. Here it just lays it out there for them as a whole. So if you were providing them sheets from the MLS, I would highly recommend that when you go to write an offer that you include this form as part of your offer so that you have it on record that you fully disclosed it, not that you just gave them a report. And then that way, when they come back and sign the bottom, they already signed the top and initialed here. Okay. Hope that makes sense to everyone. If you have questions, you can feel free to put comments in the comments section, or you can reach out to me directly. Okay. So that is the ABCD form. It's a brand new form put out in December. ABCD, anticipated broker compensation disclosure. The next one is the buyer transactional advisory. I believe we actually covered this one under the buyer representation and broker compensation agreement. This is a new form that's wrapped in with that one now. So you probably won't pull this one up separately, but if you needed to, it's the BTA form and it's attached to that form. So it just goes through all the requirements. I'm not going to go through it again because I already went through it on the BRBC day. So we're just going to scroll on past that one. The next one is the cancellation of the buyer representation form, the COBR. Think of it as the Cobra. All right. Anyways, parties and property. Realty One Fox Group, right? You put broker information there, has agreed to represent. You're going to put the buyer's names there. For the purpose of locating and acquiring real property or a manufactured home, buyer representation. The buyer representation is pursuant to a written agreement. If it was an oral agreement, you would check there. Please don't do your buyer representation in a oral agreement. But if you ever had a buyer come back and say, well, I want to make sure that our relationship is canceled, you could use this form. You would check the box for oral agreement if you hadn't signed the buyer broker representation agreement or buyer representation and broker compensation agreement. You could check that box there for oral agreement. Notice of cancellation of buyer representation. The representation may be canceled either by buyer or broker or both by signing in the applicable box below, paragraph 2, and delivering to the other party. However, compensation may still be owed based on the contractual rights under the buyer representation agreement or otherwise, right? So in that buyer representation agreement that we covered previously, you had the ability to fill out how you would be compensated, what that compensation would be, and what the roles were underneath that. So the next one is by signing the applicable box below. This paragraph 2, buyer or broker hereby gives notice to the other to cancel the buyer representation and terminate their agency relationship duties and responsibilities with and to each other. Compensation may be payable as specified below. So whoever's canceling this, that box gets checked, whether it's the buyer or you, the broker. Okay. Effective date of cancellation. If there is no written agreement between buyer and broker, or if there is a written agreement and such agreement is for non-exclusive representation, I told you guys to check that box. The cancellation is effective immediately upon or pursuant to a written buyer representation agreement blank days after receipt of this notice, right? So it's either effective immediately upon this notice. That's the default. You leave out all that middle section, or we put the parentheses back in. We check the box pursuant to a written buyer representation agreement blank days after receipt of this notice. Okay. If there is a written agreement and such agreement is for exclusive representation, the cancellation is effective 30 days after the receipt of this notice. So if we have an exclusive representation, we have the ability, we can hold them hostage if we want to. We don't have to for 30 days after they provide us the cancellation form. Regardless of the agreement between buyer and broker, the parties may agree to mutually cancel the buyer representation immediately upon the last signature in the mutual cancellation box. Okay, so that's regardless of whether it's an exclusive representation or not, we could choose to cancel it blank days after the last signature, right? So it's immediately upon or blank days after. Okay. The notice applies to all properties that may be subject to the buyer representation or only for the following properties, right? So we need to make sure we check the appropriate box. Is it all the properties that were subject to the buyer representation? Or are we only talking about 1 or 2 properties where you would be due the commission if they decided to buy them? The broker will not be the buyer's agent during any negotiation or transaction that results between buyer and seller regarding any property. Any questions that buyer has about the property should be directed towards the seller's broker, if any, or to the seller. Okay, we're not representing you anymore. It's between you guys, not us. Compensation due to broker. A written buyer representation agreement provides for compensation in the event of cancellation of this agreement. Buyer agrees to pay broker as specified in the written agreement between them. CAR Form BRBC provides in the event of cancellation, broker should be entitled to compensation for those properties for which there was broker involvement as defined in the BRBC. If any such property is acquired during the representation period, broker shall give buyer a list of such properties within 5 calendar days after receipt of this cancellation of buyer representation. Okay, so that means you have to provide them with a list. We need to be tracking what properties we're showing, what conversations we're having with other agents. You need to track all that so that you can provide it in the case that it gets canceled. Or compensation shall be paid as specified in paragraph 3 below, and only if both parties agree by signing below paragraph number 3. Buyer to obtain other advice. Broker advises buyer to obtain real estate, legal, tax, title, insurance, and other desired advice from qualified California professional. This is unilateral buyer or broker cancellation, and this is buyer and broker mutual cancellation. Okay, so this is, hey, I don't care what the other party says, I'm canceling. That would be unilateral buyer or broker cancellation, whoever's sending the cancellation. The other option is mutual, where all parties sign right here in this next box. We got buyer signatures and the broker signature. Okay, that's page 1. Page 2 goes on. Only applies if paragraph 2E2 is checked above and both parties sign below. Buyer agrees to pay broker as follows. So this is 2E2. If we come back up and reference, we got 2E2. This would be this box here as specified in paragraph 3 for compensation. Subsequent acquisition of property during representation period or extension for which there was broker involvement prior to cancellation. The amount of compensation specified in the written buyer representation agreement, if within blank calendar days after this cancellation of buyer representation or the representation period specified in the buyer representation agreement, buyer enters into contract to buy, lease, or otherwise acquire any property specified below for which the buyer physically entered and was shown property by broker. Broker showed the property to buyer virtually. Broker submitted to seller a signed written offer from buyer to acquire, lease, exchange, or obtain an option on the property, or property was introduced to buyer by broker, or one for which broker acted on buyer's behalf. Merely sending a list of properties without other documentation documented action by broker would not satisfy this requirement. So having them set up on a property drip, those properties don't all count. You actually have to have some sort of involvement. Okay, we would put that list here. Okay, expenses accrued would be the other option. Buyer agrees to pay broker blank for out-of-pocket expenses, costs incurred, and services rendered to buyer prior to the cancellation of buyer representation. Right, so we may say, hey, we're releasing you from your obligation to pay us. We're canceling this, but as part of this, we acquired these fees. You're responsible to cover those. The broker to receive a referral fee. Broker will receive a referral fee from another broker pursuant to a separate written agreement with broker. So if we're done with this buyer, we're referring them to another broker. We can say, hey, we'll take a referral fee. That would be box C. D would be broker to receive compensation from seller. Broker pursuant to a separate written agreement will receive compensation from the seller as compensation for services provided and completed. No compensation, buyer owes no compensation to broker. F, subsequent acquisition of property during representation period or extension regardless of broker involvement. This paragraph only applies to an exclusive buyer representation agreement for which there was no contractual right of cancellation. The amount of compensation specified in the written broker buyer representation agreement, if prior to the end of the representation period specified in the written buyer representation agreement or any extension, buyer enters into a contract to buy, lease, or otherwise acquire property specified in the buyer representation agreement. This states that if we had that exclusive box checked and we described the type of properties they were looking for in the areas that they were looking for, and we're still within our term, they're canceling it early, that we would still be due that commission if they close on a property. Okay, G is other. Buyer and broker each acknowledge by signing below that they've received a copy of this cancellation of the buyer representation and have read, understands, and accepts its terms. Buyer's going to put their information there. You make sure your information is completed and everybody signs down there. Any questions about the COBRA, the COBR form? All right, moving right along. Another form that came out as part of the, here's the notice of, okay, that was the cancellation. Here's the notice of broker involved properties. So if you're going to provide the notice of broker involved properties, there's another form for that, which was birthed out of that new buyer representation and broker compensation agreement. So this one's also referenced. So anytime there's a cancellation and we're going to provide notice, this would be the notice of broker involved properties. Okay, this falls under anything that doesn't fall under that exclusive right. The notice of broker involved properties is being provided to you as required by the written buyer representation and broker compensation agreement between, you're going to put the buyer's names in there and the broker's name next, the representation agreement. The representation period, the representation agreement commenced on blank date and expires or was extended to or terminates on blank date. That would be the representation period. Compensation agreement. Buyer has agreed to pay broker compensation provided for in the representation agreement for property described in paragraph 3 of the representation agreement and for which there was broker involvement. A broker involved party as follows. If buyer enters into contract to acquire a broker involved property within a specified number of calendar days after the expiration of the representation period or any extension, and broker has provided to buyer a written list of broker involved properties in paragraph 4 prior to the expiration of the representation agreement or any extension. If after cancellation of the representation agreement, buyer enters into contract to acquire a broker involved property during the representation period and broker has provided buyer a written list of broker involved properties in paragraph 4 within 5 days after receiving notice of cancellation of the representation agreement. Okay. There you go. That's what outlines when you're due commission. Broker involved properties is paragraph 4. Broker involvement means any of the following. Buyer physically entered in and was shown the property by broker. Broker showed the property to buyer virtually. Broker submitted to seller a signed written offer from buyer to acquire, lease, exchange, or obtain an option on the property, or the property was introduced to buyer by broker, or one for which broker acted on buyer's behalf. However, merely sending buyer a list of properties shall not be deemed broker involvement without documented action on the part of the broker, such as analyzing the property for the buyer, specifically assisting buyer in the potential acquisition of the property, or communicating with the seller or seller's agent regarding the buyer's potential acquisition. Pursuant to the representation agreement, broker identifies the following property for which there was a broker involvement. If you don't want to type them all out and you have a list, you could check this box here. If checked, see attached broker involved properties, or see list of broker involved properties. Okay. Notifying new broker. If buyer intends to enter into another buyer representation agreement with another broker, buyer is advised to provide this notice to that broker. Failure to do so may obligate the buyer to pay 2 commissions. The date of the notice, this notice of broker involved properties is being provided to buyer on blank date. You're going to sign, make sure all your information's completed out. I acknowledge receipt of a copy of this notice of broker involved properties. Buyer signs and dates here. Any questions about that NBIP, notice of broker involved properties? So many forms. Basically, if you breathe, there's a form to fill out. Okay. The next one is the seller's payment to buyer's broker. Okay, this was also mentioned in that buyer representation and broker compensation agreement form, that you have the ability to negotiate with the seller the commission. And it's also in the new revised RPA, the residential purchase agreement. So seller payment to buyer's broker. The following terms and conditions are hereby incorporated and made part of the purchase agreement or other dated blank. Property known as, you fill out the property address in which buyer, you fill in the buyer's names, and you fill in the seller's names is referred to as seller. The amount of rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Real estate commissions include all compensation and fees to broker. Buyer has entered into a written agreement to compensate buyer's broker blank % of the purchase price, or if checked, flat fee for the purchase of the property, right? That would you would take straight from the BRBC. As of the date of this seller payment for buyer's broker document is signed, the buyer and pursuant to the MLS, signed by buyer and pursuant to the MLS or blank, seller's broker has agreed to pay buyer's broker X %, right? So if you had 3% here and they're paying 2.5%, you'd fill in 3% on line 1 and 2.5% on line 2, whatever's specified in the MLS of the purchase price, or if checked blank upon completion of the transaction, that would allow for a flat rate as well. Seller agrees to pay buyer's broker blank % of the purchase price, or if checked blank, insert a % or amount, whichever is no greater than the applicable percentage or amount in paragraph 1, less the applicable percentage or amount in paragraph 2. Okay, clear as mud, right? So if I put 3% here and they've got 2.5 here, then I would put a 0.5% here, right? The amount in paragraph 1 less the percentage in paragraph 2. So paragraph 1 minus paragraph 2 equals paragraph 3. Buyer authorizes the escrow holder upon request to deliver seller a copy of the portion of the written agreement between buyer and buyer's broker, identifying the amount of compensation buyer has agreed to pay buyer's broker. If buyer's broker is the same as the seller's broker, then the amount specified in the MLS shall apply in the manner specified in paragraph 2 and 3. Additionally, if the broker has agreed in a listing agreement to a reduced amount of compensation in the event of dual agency, the amount of compensation specified in the MLS will still apply to offset the compensation that the buyer has agreed to pay buyer's broker. Okay. Be very careful with that when you start talking about like a reduced fee for dual agency. You really want to specify in your listing agreement that it would be a reduced fee if the agent represents both the buyer and the seller in the transaction, because dual agency is with any other agent inside that brokerage. Okay, so just be careful with that. By signing below, buyer and seller each acknowledge that they've read, understand, accept, and have received a copy of the seller payment for buyer's broker. Okay, so that's how you would, this was the form you would use to negotiate up on the commission. Buyer sign, seller sign, you'd submit it as part of your offer. Any questions on that seller payment to the buyer's broker? And if you're watching this in the replay mode, feel free to put it in the comment section below, and I try to keep a close eye on those. All right, we're going to keep moving on forward to the rental property owner disclosure. I'm just going to touch on this form right here, because this may come into play. This is supposed to be with a lease listing, right? Or a property management agreement. It may come into play with your RLAS. So just be aware of that. It shouldn't, but it may come into play with that. So just be aware that there's a form for your owners to fill out for rental properties, right? It's like a TDS for transfer disclosure statement for rental properties. So it's between the landlord and you would give it to the potential renter. Okay, so that's all the new forms I'm going to cover. I'm not going to cover, there's some other ones that were property management related. We don't deal much with property management, so I'm just going to let those fall by the wayside. You can kind of do your research on those. So those are the new forms that have been introduced as of December of 2022. We're going to hop on over and I'm going to show you the changes to the forms because there's some other forms that have changes. So we'll cover those next. We're going to start with the, hold on, just scrolling through them. We're going to start with the RLAS because it doesn't have any red on here. So I'm not exactly sure what has completely been changed on here, but I know there are some areas. So the RLAS is the residential lease after sale. So this is what we'd use if a seller is going to remain in possession after the close of escrow for 30 or more days. So we use the seller in possession form, the SIP form, for 29 or less, and this form for 30 or more. Most of it looked pretty close to the same. It does reference some of the newer forms in here. We've got security deposits, security deposit not returned until they vacate. We got parking, utility, condition. Oh, so this section 10, the condition of premises, I know this section is new. Tenant has examined the premises and if any old furniture, furnishings, appliances, landscaping, and fixtures, including smoke alarm and carbon monoxide detectors that are owned by the housing provider. We're either going to check one of these 6 boxes here. Tenant acknowledges that these items are in the condition disclosed and agreed to be delivered in the purchase agreement, right? That's the easiest one. Like, hey, whatever the condition was during the sale, that's what it still is. Tenant acknowledges these items are clean and in operable condition with the following exceptions. So they might want to note something there. The tenant acknowledges the condition of the premise of these items is contained in the attached statement of condition car form MII. That's one of the new forms that was released that I'm not going to cover. The housing provider will deliver to tenant a statement of condition, that'd be car form MII, within 3 days after execution of this agreement, prior to commencement date, or within 3 days after commencement date. Make sure you check one of those boxes. Tenant shall complete and return the MII to the housing provider within 3 days after delivery. Tenant's failure to return the MII within that time shall conclusively be deemed tenant's acknowledgement of the condition as stated in the MII. Okay, so they have the option to review and then fill out their portion of it. Tenant will provide housing provider a list of items that are damaged or not in operable condition within 3 days after commencement date, not as a contingency of this agreement, but rather as an acknowledgement of the condition of the premises, or F is other, because our car forms love that other line. So there is that information there. So make sure you check one of those boxes. Okay. It outlines who is going to continue watering the garden, landscaping, trees, shrubs. We need to make sure we check that box. And it added this box for HOA because that previously wasn't there. This section's also a little different. So we want to make sure that we mark the boxes, and there may be more than one box marked, right? So the HOA might water the garden, landscaping, trees, and shrubs, except for the backyard. And then the tenant shall maintain the garden, landscaping, trees, shrubs, except the front yard, right? So it depends what that HOA maintains. Then you got housing provider or tenant. So housing provider would be the buyer of the property. Okay. Housing provider becomes the buyer of the property because this is the residential lease after sale. So they're becoming landlords. Okay. Let's see here. Neighborhood conditions, pets, except signed in the attached pet form. That one's been around for a while. We got rules and regulations, which has always been part of this, alterations and repairs, keys. I think everything else is pretty standard. There might be a few other terms that were changed in this, but they're pretty close to the same form as what was on the original one. Tenants' obligations. Right, so it gives them their right to, here's where the NTT comes into play, or the NRI, which were a couple new forms as well. These are the move in and move out inspection reports, so just be aware of that. They can ask that to be done. So just make sure you read through this, but most of it is still very similar to what the original form entailed. Okay. Nothing super scary there that's new. I mean, the whole form's a little scary, but it's all right. And I think it gives a place now for an entity tenant and an entity housing provider. Everybody gets to sign this as well as the brokers. All right, that's all I'm going to cover on that one. Just know that there are some changes there. Usually they highlight them red for me, so it makes it really easy to scroll through them and check. So I started with the hardest one first. Close that one out. So that was at RLAS. We're going to move along to the RPA, which is the residential purchase agreement. So they made some changes to this. Notice they updated the date at the top, right? So we always know we have the most current one. So it was 12/22. And remember, they update forms generally in December and June. They like to screw up our end of the year when we're trying to close transactions or meet our goals by changing up the forms, and then in the middle of summer. So that while you're out vacationing with your family and you're trying to draw up an offer really quick and you pull it up and everything looks different, you're thoroughly confused. So they do that on purpose. No, I'm joking. We have the loan amount. The first change, the nice one about this is it's red highlighted. It won't be this way in your car forms library. Loan amounts. So right where the loan amount is, we used to have the first loan amount and an interest rate, whether it's going to be fixed or adjustable. And then it would say points not to exceed, right? And you would put an amount there. buyer to pay up to blank points to obtain the rate above. So this would be your fixed rate, not to exceed. So if your buyer's rate is 5%, I usually round up just a little bit there, like maybe 5.25. I want to protect my buyer, but I don't want to freak the seller out at the same time when I submit an offer. And then it says buyer to pay up to blank points to obtain the rate above. So it's not locking the buyer into paying 2 points. It's they're willing to pay up to blank points to reach that rate on the disclosure. Okay, so you can fill in a line there. So that's a new little line there. And then also on the additional finance amount, it's the same change right there. They just added a little dot to not exceed, and then buyer to pay up to blank points to obtain the rate. As we scroll further down and we get to G3:18, right, G3 right here, it references paragraph 18. Seller agrees to pay the obligation of the buyer to compensate buyer's broker under a separate agreement. That would be that SPBB form that we looked at earlier. Seller's broker's offer, if any, to compensate buyer's broker is unaffected unless otherwise agreed. So, right, so the seller's still offering what they were offering to the buyer's broker because that comes from the seller's broker's portion, and the seller's agreeing to pay the difference. Okay. I highly doubt we're going to see very much of anything happen with G3. I would be surprised. But if we start having a lot of sellers that aren't offering compensation, that's where it's going to come into play. Or people start cheapskating it and offering a highly reduced commission below what we would consider like average, I'll say, for our office, because we're not allowed to talk about it outside of that. So we'll just leave it at that. Up here we have they added the word delivery, right? So review of seller documents is 17 days after acceptance or 5 days after delivery, whichever is later. So they just updated this word on all of these contingencies. Not a big change there. We knew that's what that meant. In addition, I don't think, well, they did. All right, moving on to possession. Line M3 references paragraph 4A and 7A, occupied units. They've added the words, hey, it's not just occupied, it's occupied by tenants or anyone other than the seller. Okay, let's clarify. I think that was a good clarification. They gave us a little box to check here for the TOPA form attached, the tenant occupied property addendum, and then added a little additional term, seller shall disclose to buyer if occupied by tenants or persons other than the seller and attach TOPA in a counter offer if not part of the buyer's offer, right? So if the buyer knows that's a tenant occupied property or not seller occupied and it's not vacant, then we should be including that TOPA form with our offer. If we were bamboozled and we had no idea that wasn't the seller that was living in the house, then, and we made the offer without that TOPA form, then the seller should counter offer us stating that it's tenant occupied and attaching a TOPA. Okay, so if you have a listing and it's tenant occupied, buyer makes an offer without asking for this or without acknowledging that it's tenant occupied, we need to counter them. Don't enter into contract and then do it as an AEA. Please counter them with the TOPA. Okay. Here we have sign and return escrow holder provisions and instructions 5 days after delivery. I like that, right? I think it used to be 5 days after acceptance. So this gives us 5 days after delivery in case the title company takes 2 weeks to get us that form. Fair. Nothing else changed on this part of the grid until we get to Q18. 10C home warranty plan chosen by buyer. Coverage includes but not limited to, right? So we could, the buyer can add to their coverage, but it has to include the following items. And if seller or both check the seller's cost not to exceed blank. Okay, issued by. So we're not even going to say, hey, we're going to split it 50-50 anymore. If we split it 50-50, that's totally fine. We just need to cap it at what the obligation is going to be. So we can't go buy a $4,000 home warranty policy. Okay, so that's why they're capping it there. They added the mixed use purchase addendum, the MUPA here under the other property advisories. Under the deposit, the retention of deposit, they added a couple numbers and then added an and line that says regarding possible liability and remedies if buyer fails to deliver the deposit. Okay, so this means, hey, let's just read this section real quick because this could be important. Paragraph 29, if initialed by all parties, that's the liquidated damages clause. or otherwise incorporated into this agreement specifies a remedy for buyer's default. Buyer and seller are advised to consult with a qualified California real estate attorney before adding any other clause specifying a remedy such as release or forfeiture of deposit or making the deposit non-refundable for failure of buyer to complete the purchase. Okay, sometimes we add different verbiage in there. Any such clause shall be deemed invalid unless the clause independently satisfies the statutory liquidated damage requirement set forth in the civil code and regarding possible liability and remedies if buyer fails to deliver deposit. Okay, so there was a big movement going on where the buyers just wouldn't put their deposit in escrow and then they would cancel the contract. They'd make multiple offers on properties. So just be careful. All right, moving right along to our occupancy, closing and possession, 7A. If buyer intends to occupy the property as a primary or secondary residence, paragraph 3E3, and unless otherwise agreed, such as in car form TOPA, the unit buyer intends to occupy shall be vacant at the time of possession, is delivered to buyer, and the property, if the property contains more than one unit within 3 days after acceptance, buyer shall give seller a written notice of which unit buyer intends to occupy. Occupancy may impact available financing. Seller shall disclose to buyer if occupied by tenants or persons other than the seller in attached form TOPA in a counter offer if not part of the buyer's offer, right? So if it's a multi-unit, number one, we're saying the seller is going to deliver it vacant. Okay, if they're going to occupy it as their primary or secondary residence. And if there's more than one unit, the buyer's going to disclose which unit they're going to occupy so that the seller can deliver just that unit vacant. The other ones may remain, have tenants that remain in possession. Okay, super simple addition there, adding some more clarification. Down here under review of seller documents, this agreement as specified in paragraph 3L4, contingent upon buyer's review and approval of seller's documents required, right? So we aren't just reviewing them, we actually have to approve of those seller documents. We let the seller know that we approve of them by removing that contingency and returning all the forms signed back to the seller's agent. Here again, we have buyer's review and approval of those common plan development disclosures. Down here under removal of contingency or cancellation for any contingency specified in paragraph 3L or 8 or elsewhere, right? They added or elsewhere in case you put it on an other line, right? So you've got that there. Here we have after delivery, 5 days after delivery of seller's documents, right? So we're going to back that up. For contingencies for review of seller documents, preliminary title report, condo plan development, disclosures, buyer shall within the time specified in 3L or 5 days after delivery of seller documents, or CI disclosures, whichever occurs later. Okay, right? Whichever occurs later, remove the contingency in writing. Down here, items included in sale, it just says, here we're clarifying again, window and door screens, awning, shutters, window coverings, which includes blinds, curtains, drapes, shutters, or other materials that cover any portion of the window and any associated hardware and rods. Okay, we're just clarifying that not just the curtains stay, you can't leave them on the ground, the rods and everything come with it. So if your sellers don't want to include curtains and rods, please make sure that you put it in writing before you accept the offer. Okay. Otherwise, curtains, drapes, rods, window valances, everything goes with the house. Also, the pool heaters also remain with the property in case there was ever a question. Make sure the pool heater stays. Down here on non-dedicated devices, it just says seller shall delist any devices from personal accounts and shall cooperate with transfer of services to buyer. So that's like, if you have your Ring doorbell that gets transferred, you've got to delist it with yours so that the new buyer can accept it and put it under their profile. Same thing with like smart device. If you had any smoke detectors and the thermostats on the wall, all those things have to be delisted so they can get repicked up by the new buyer, and that you're going to help transfer that service to the buyer if there's needs any help or questions. Okay. Inspection reports, they've added the word test here. So inspection reports, tests, and certificates all fall under the allocation of costs. They've added inspection report, test, certificate there. In any such document, right? So here we'll just read the whole paragraph because they've made a couple changes. Tests and certificates, paragraph 3Q 1, 2, 3, 4, 1, 2, 3, and 5 only determines who is to pay for the inspection, report, test, certificate, or service mentioned. It does not determine who is to pay for any work recommended or identified in any such document. Agreements to payment for work required shall be specified elsewhere in paragraph 3Q or 3R or in a separate agreement, such as car forms RR, RRRR, ADM, or AEA. Should not be on an addendum unless it was submitted with the original offer, just so everybody understands. Any reports in these paragraphs shall be delivered in the time specified in paragraph 3N1. Okay, so deliver the reports. Down here, the home warranty plan and optional coverage, right? Buyer shall choose the home warranty plan and any optional coverage. And down here, it just talks about buyers advised to investigate these coverages to determine those that may be suitable for the buyer and their costs. Okay, so it just added a little bit more clarification around the home warranty. All right, solar systems. There's a whole, why didn't we see the form for this? There's a whole form for this. Maybe the form was always there and they just changed it. Now I'm gonna have to go back and look for it. Solar systems for properties with any solar panels or solar power systems, seller shall within the time specified in paragraph 3N1 deliver to buyer all known information about the solar panels and solar systems. Seller may use the solar advisory questionnaire, car form solar, right? So there's a car form solar now, and you can use that. That helps to disclose any information you have about those solar panels. Known material facts. They talked about here, the seller shall within the time specified in 3N1 disclose known material facts and defects affecting the property, including but not limited to insurance claims within the past 5 years, or provide buyer with permission to contact insurer to get such information. That would be car form ARC. That gives them the ability to contact their current insurer of the property, okay, to get any claims information. Buyer investigation of property and matters affecting the property. Down here under 2, they added 2, and then they said investigation of any matter affecting the property other than those specified as separate contingencies. Buyer investigations include but are not limited to an investigation of the availability and cost of general homeowners insurance, flood insurance, and fire insurance. Okay, so they've updated that to make sure that people understand that contingency, that investigation contingency also includes insurance, that if they get a quote for insurance and it's more than the buyers want to pay for insurance, the buyers can cancel the agreement under the investigation contingency. We knew that, but now they're specifying it. Here, they just updated some of the paragraphs, 7A, 11, some of the stuff in there, seller delivery of documents. Down here under compensation, paragraph 3G, seller shall be entitled to a copy. If seller agrees to pay buyer's broker, see paragraph 3G3, seller shall be entitled to a copy of the written portion of the compensation agreement between the buyer and the buyer's broker, identifying the compensation to be paid. See form, car form SPBB. That was that one that we went over already. They've just incorporated that in. They've updated this with an additional paragraph. Assignment or nomination. Parties shall provide an assignment agreement to escrow holder within 1 day after the assignment. Any nomination by buyer shall be subject to the same procedures, requirements, and terms of the assignment as specified in this paragraph. So they just updated one of the terms there. So it's not just assignment, it's also nomination. Legal holiday shall mean any holiday or optional bank holiday under Civil Code 7 and 7.1, any holiday under the Governmental Code 6700, okay, or any day that the lender or escrow holder under this agreement is closed, right? The close of escrow shall occur on the next day the recorder's office in that county, the lender, and the escrow holder are open. So it has to be all 3 parties being open, or it's considered a holiday. The recorder's office could be closed, but escrow and lender are in service. That is still considered a holiday, or the lender could be on holiday and everybody else. And that doesn't mean a vacation. That means like the whole lender's office is closed, right? Okay, so that's what they mean there. Electronic copy or electronic signature, unless otherwise agreed, buyer and seller agree to the use of electronic signatures. So it's writing that in here, saying that we're okay with that. In the arbitration of disputes, down here under the preservation of actions, they added some terminology down there. Provided the filing party concurrent with or immediately after such filing makes a request to the court for a stay of litigation pending any applicable mediation or arbitration proceeding, right? So the following shall not constitute a waiver nor violation of the mediation or arbitration provisions. So that's like if you file a court action to preserve statute of limitations, the filing of court action to enable the recording of a notice of pending action, or for an order of attachment, receivership, injunction, or other provisional remedies, provided the filing party concurrent with or immediately after such filing make the request for a stay of litigation pending any applicable mediation or arbitration proceeding. So like if the seller is refusing to sell the house to you, you can file a notice of pending action or an injunction or whatever against it. But you also have to file at the same time that mediation. Okay, that means that you didn't violate the terms of the mediation and arbitration. They added another 5 down here. If the entity is a trust under probate, the following is the full name of the trust or probate case. They did the same thing under the seller's signature. Agents now have, I don't know why they updated this because I thought it had address, city, state, phone, email previously. Check all that apply for a designated delivery addresses, and it's email above, text to, phone number above, or alternate. So you don't have to, oh, they've included it in the same line. The email and phone previously was on a separate like line item, and now they've included it unless it's an alternate. And same thing over here with the seller's brokerage firm. So that's all the changes to the residential purchase agreement. Nothing super major. It really just references back a lot of clarification going on there. It's probably good things that they clarified. And we're going to keep on plugging away. But now I'm curious about that solar form, if I have that down here. I don't, so I just totally missed it. Oh, well, all right. We'll come back to that. Let's go to the MH purchase. I think this is the right one. This is the mobile manufacturer mobile home purchase addendum. So we use the regular purchase agreement and then we wrap in the manufactured or mobile home purchase addendum. If you're purchasing a manufactured or mobile home, I'm not going to go through this whole form because we're only going to cover the red letter items. It's almost like reading the Bible. We just cover the red letters. Caution, occupancy and condition of property. I'm glad I'm entertaining Heather this evening. Oh, like Anastasia is joining us too. Let's see here. We're just going to say, notwithstanding that the agreement to which this addendum is attached may provide that the property is sold as is, buyer and seller acknowledge that sellers not using a licensed real estate agent or a licensed manufacturer home dealer are prohibited from selling a personal property manufactured home as is, unless the manufactured home meets as applicable the requirements of the HCD or the National Manufactured Housing Construction and Safety Standards Act of 1974, and the licensed real estate agent or manufactured home dealer, if any, must conduct a reasonably competent and diligent visual inspection of the home and disclose material facts that such an investigation would reveal, right? Do your AVID report, whether it's a mobile home or a regular home. Occupying a used manufactured home or mobile home, even though a manufactured home or mobile home may be sold in its present physical condition, the Mobile Home Parks Act prohibits the occupancy of a manufactured or mobile home wherever located. Those standards are set forth in the Health and Safety Code as follows. It is unlawful for a person to use, cause, or permit to be used for occupancy any of the following manufactured homes or mobile homes wherever the manufactured homes or mobile homes are located. Any manufactured home or mobile home supplied with gas, fuel, water, electricity, and sewage connections, unless the connections and installations conform to the regulation of the department. Any manufactured home or mobile home that is permanently attached with underpinning or foundation to the ground, except for a manufactured home or mobile home bearing the department insignia or federal label that is installed in accordance with this part. Any manufactured home or mobile home that does not conform to the registration requirements of the department. Any manufactured or mobile home that is unsafe or unsanitary condition. Any manufactured or mobile home that is structurally unsound or does not protect its occupants against the elements. Okay, so a little caveat there. Make sure you know what you're buying. Okay, that's the changes to the mobile manufacturer mobile home purchase addendum. The occupancy is really important. We're gonna close that one out. There's another, I think it's this one. This is the manufactured home and mobile home transfer disclosure statement. So we used to just use the regular TDS, and now Just make sure you know that there's oh, that's not true. We always use this one, the manufactured home TDS. So it's been some changes on here. We're going to scroll down. It's a lot similar to the regular TDS, but it's specific for manufactured or mobile homes. It says it was revised. I'm not exactly sure what was revised on here. So there's only red dates. So I'm not exactly sure what was done, but just make sure that you utilize this form. And technically it's your seller that's using it. They should be reading it completely. I'm wondering if this form is going to be available on Glide. I hope it is. All right, moving right along here. We've got the, let's go with the ETA, the extension of time addendum is what it used to be called. And now it's an amendment, which is actually the accurate term. I'm glad they updated it. So it's an extension of time amendment because we're amending the previous time period in the contract. This is a proposal to amend the terms of the conditions of the purchase agreement. I appreciate that it's now a proposal and I don't have to accept it as the seller or buyer. Offer expiration. So everything's the same except down here, offer expiration. The buyer or seller proposes, look, we can extend the time of the offer now. Yay. Everybody cheered for joy. There's an actual form to be able to extend the offer deadline. The seller, so if somebody submits to you an offer that's got like a 12-hour turnaround and you know you're not going to make it in that time period, this is where you can say, hey, seller proposes an extension of time of the offer expiration to such and such date. And then you can send it off, right, to the buyer for signs that they know that, hey, we're not reviewing offers until Monday, deal with it. All right. Buyer or seller proposes this extension of time, which may be withdrawn by the party initially in this proposed amendment at any time prior to acceptance and which shall be deemed revoked unless on 5 p.m. And that's interesting. It gave me like a little drop down on the third day after it is signed by the initialing party or by blank date at blank time on, or sorry, by the time on blank date, this proposed addendum is signed by the other party and a copy of this amendment is delivered to the initialing party. By signing below, buyer and seller acknowledge that each has read, understands, and receives a copy of this and agrees to the terms of the extension of time amendment. Okay, so both parties have to sign for it to be in effect. I'm a little sad though that they didn't give us a reject. I wish they would give us a reject, not just we don't respond. Maybe they'll add that in June. But at least now we can extend the offer with this form instead of being like, I don't know, an addendum, I don't know, a counter offer, how do we extend it? Right? So now we have the ability to do that. Oh, look, oh, all right. All right, so that's the extension of time addendum. I think we can make it through these forms, guys. All right, we got the buyer counter offer. There's some changes there. Paragraph 1D of this or another counter offer, and then they added some verbiage to B, C, and not D, they just renumbered it. So B is now, unless otherwise agreed or altered in another counter offer, down payment and loan amounts will be adjusted in the same proportion as they were in the original offer. So, right, if we were offering a 10% down payment and we're countering on price, everything adjusts with that price. But the dollar amount of any initial and increased deposit and seller credit shall remain unchanged from the original offer. Okay, so keep that in mind. Like if the original offer was a $5,000 deposit, it's not going to adjust to and it was 1% of the offer price. If we're countering them a higher offer price, it's not going to adjust. So if we want the deposit to be increased, we need to counter offer that. Okay, so your down payment, your loan amount is going to adjust in the same proportion. Your deposit will not. C is unless otherwise agreed or altered in another counter offer, if in the original offer, the appraisal contingency amount is lower than the original offered price, right? So if that appraisal line, like we offer 500,000, but we say, hey, as long as it appraises for 480, we're good, right? The dollar amount of any difference, the appraisal gap shall be deducted from the final contract price to create the final appraisal contingency amount. So what that's saying is if we give a $20,000 gap and they're countering us at 550 instead of 500, that same 20,000 gap remains. It doesn't go with a $70,000 gap. Okay, so it's the same dollar amount. Whatever it was subtracted from the original offer to get that number, it's subtracted from the final purchase price. Okay, so those were the changes there on the buyer counter offer. Super simple, nothing scary. I like those clarifications. I appreciate what they've done in this update. Here in the seller counter offers, that was the buyer counter offer. We have unless otherwise agreed or altered in another counter offer. Down payment loan amounts will be adjusted in the same proportion as the original offer, but the dollar amount of any initial and increased deposit and seller credits shall remain unchanged from the original offer. So keep this in mind that it's not just the deposit and increased deposit, it's also the seller credits are going to remain the same as the original offer. So if we asked for $10,000 in seller credits, it doesn't adjust with a change to the purchase price. It stays $10,000 unless otherwise agreed to. KC is the same appraisal gap verbiage that was in the buyer counter offer. So nothing scary there. And then they just had to renumber a couple things because they renumbered and added C. Okay. We also are going to see the same thing over here in the seller multiple counter offer that we have available, right? Same thing as in that seller counter offer, exactly the same. It just says SMCO at the top instead of the SCO. Any questions about those counter offers or any of the forms I've covered thus far? All right, I'm just going to continue plugging along. I'm actually glad you didn't have any questions because I actually X'd out of them, so it would take me a minute to reopen them. But if you have any questions or think of any questions, feel free to reach out to me directly, and you can also put it in the comments section. I'll look it up and answer your question. Here we have the cancellation of contract, disposition of deposit, and cancellation at escrow. I promise you every 6 months they update this form and change it because they just can't get it right. Both paragraphs 1 and 2 are escrow instructions to the escrow holder. Cancellation under paragraph 1A requires the signature of either the buyer or the seller, but not both. Paragraphs 1B and 2 require the signatures of both parties to be effective. So what that means is that one party cancellation. Here are the reasons that we can cancel the contract and we don't need the other party to agree with us. Okay, the buyer or seller signing below cancels the agreement. You're going to check one of the boxes. B is proposed mutual cancellation. And then they added some more verbiage at the end of that, right? So it's only effective if agreement is reached by both parties, signed in paragraph 2 below as follows. This proposed mutual cancellation may be withdrawn by the party initialing it at any time. I keep saying initialing, and what I really mean is initiating. I said that on the other extension of time amendment as well. It's initiating it at any time. Whoever initiated it can withdraw it prior to the agreement by the other party. And in paragraph 2 below, and 2 shall be deemed revoked unless by 5 p.m. on the third day after it is signed by the initiating party in paragraph 1 or by blank date on blank time it is signed by the other party in paragraph 2, and a copy of this completed form is delivered to the initiating party. Okay, so in order to have proposed mutual cancellation, it has to be signed and agreed to by both parties, and they've put some time frames now in there of when that would be valid. Okay, let's see, that's the only thing that's changed right there, just those 2 little things there for the cancellation. So they're just adding more clarification. We're going to keep on plugging along. The California Consumer Privacy Act Advisory Disclosure and Notice. This is my favorite form. It used to be like 3 pages and they shortened it down to 1, and now they're adding some more words in there. So now it was amended. The California Consumer Privacy Act was amended by California voters in 2020. So they added that in there. Under the CCPA, you're are required to grant you various rights in your PI, including the right to know what PI is collected. That'd be personal information, in case you're like, Amy, what is PI? That's personal information. The right to know what personal information is sold or shared and to whom, the right to request that the business correct or delete your personal information, and the right to opt out or stop the transfer of PI to others, and the right to limit the use of certain PI which is considered sensitive. Okay, moreover, businesses that are otherwise covered under the CCPA may have a legal obligation to maintain personal information, notwithstanding your instructions to the contrary. And additionally, the California Privacy Protection Agency is authorized to promulgate regulations which may further clarify regulations of the CCPA. There you go. They added more legal jargon in there, so it makes that form totally and completely understandable. And it's 5 o'clock, but I'm going to go back to that solar form real quick. So give me 2 seconds because I got to reopen up my car forms library if I can move you guys around because I don't think I have it open still. I'm just really curious about the car solar form. So let's look at that real quick and see if that's a new form or if it's just been there and nobody ever uses it. And then we're finished. We don't even have to continue next week. Does anybody have any questions while I'm getting logged into the car forms library to look up that solar form?
Nope.
Amy, what, when you were talking, sorry, I was over on the other side of the room. When you were talking, oh my goodness, when you were talking about the home warranty,
Yes.
what did you say that they added on that? Because you scrolled, but I didn't see what it was that they added on that home warranty area.
Yeah, luckily I remember that one. So on the home warranty information, they put the options, they put on the options, it says that to buyer to choose the home warranty and options to include but not limited to. So the buyer can always upgrade the home warranty outside of those limitations. And then on the end of it, it specified that if the seller box or the both boxes checked where they're sharing the cost of the home warranty, that you need to cap what the seller's going to pay, which prevents the buyer from going out and picking like a $4,000 home warranty program and the seller being obligated to pay $2,000 of it because they agreed to split the cost. So you're gonna cap the seller's side.
So like you taught me, I can still put all that in there, like the
Absolutely.
name of it. Oh,
Yep.
okay.
Yep. You would still put the name and you would put what updates and upgrades they want and who's paying for it. But it just allows the buyer to not be limited to that home warranty, that if they want to, like if you said, hey, the seller's going to pay $550 of the home warranty, and then the home warranty that was specified is only $480, the buyer could add another option there. And
okay.
obligated to pay that amount up to the max amount.
Oh, okay. Okay. Thank you.
Yeah, absolutely. So let's look up this solar form. Oh, it is in here. I just didn't include it. All right, so let's look at the solar advisory and questionnaire. Oh, there was a couple other forms. How did we miss all these forms? I'm so sad. All right, hold on. We got like 2 more forms to go over. I was doing so good. Now I'm flailing. All right, hold on. Let me look. I went over the anticipated broker compensation disclosure, the buyer transaction advisory, the cancellation of buyer representation, the notice of identified property, the seller payment to buyer broker, the rental property owner disclosure, and then we have there we go. All right, the solar advisory and questionnaire is a new form, as well as the non-contingent offer advisory. We're going to go over this one first because it's shorter. So the non-contingent offer advisory, market conditions. So if you've got a buyer making a non-contingent offer in any way, we'd want to include this form. Buyer has been informed and aware that the market conditions are cyclical and change over time. In a competitive or hot market with limited inventory, buyers will sometimes consider making non-contingent or contingent-free offers in an attempt to convince the seller to accept their offer instead of another's. These type of offers have no contingencies for a physical inspection of the property, for obtaining a loan, for a minimum appraised value, for other investigations of the property, or for matters which are commonly included in the residential purchase agreement at other times. Non-contingent offers. Most residential purchase agreements contain contingencies allowing a buyer a specified period of time to cancel the purchase if the buyer cannot obtain a loan, if a buyer is dissatisfied with the property's condition after inspection, if the property does not appraise at a certain value, or if for any reason any other contingency within the purchase agreement. Personally, just so everybody knows, I would include this with all of my offers. Or I think this is actually, we may have gone over this because I think it's included with the buyer representation agreement. I would include it with that because that way the buyer knows up front what their options are. To make their offers more attractive, buyers will sometimes write offers with few or no contingencies or offer to remove contingencies within a short period of time. In a hot market, sellers will sometimes insist that buyer write offers with no contingencies. While making a contingency-free offer may give buyer a better chance at getting the seller to accept their offer, there are risks in writing such offer. Broker recommends that buyers do not write non-contingent offers, and if you do so, you are acting against the broker's advice. However, if you do write a non-contingent offer, there are some of the contractual rights you may be giving up. The loan contingency. A loan contingency for you allows for you to cancel the contract without penalty if during the contingency period you cannot obtain the loan specified in the agreement. That includes the interest rate. If you give up your loan contingency, you cannot obtain a loan, whether through your fault or the fault of your lender. As a result, you do not or cannot purchase the property. You may legally be in default under the contract and required to pay damages or forfeit your deposit to the seller. Appraisal contingency. If an appraisal contingency allows you to cancel the contract without penalty, if during the contingency period your lender or your own appraiser does not believe the property is worth what you have agreed to pay for it. If you give up your appraisal contingency and the property does not appraise at the specified price, your lender may not loan the full amount needed for the purchase or may not loan any amount at all because of a low appraisal. As a result, if you are not capable of purchasing the property, you may legally be in default under the contract and could be required to pay damages or forfeit your deposit to the seller. The seller is not obligated to reduce the purchase price to match the appraised value. Investigation contingency. An investigation contingency allows you to examine the property and matters pertaining to it, such as availability and cost of insurance. If you give up your investigation contingency, you could lose the right to cancel based on the information you later discover, which is why it's important to conduct investigation early. However, even if you make an offer without an investigation contingency or you remove that contingency, the seller may still be obligated to disclose to you material facts about the property. In some cases, once you receive that information, the law gives you an independent right to cancel for a limited period of time without an investigation contingency. If you disapprove of the condition of the property and as a result, you do not want to purchase the property, you may legally be in default under the contract and required to pay damages or forfeit your deposit to the seller. Broker recommendations. The broker recommends that you do not write a contingent offer, even if you are planning on paying all cash for the property. If you intend to write a non-contingent offer, broker recommends that prior to writing the offer, you review all available seller reports, disclosures, information, and documents. Have an appropriate professional inspect the property, even if it's being sold as is in its present condition, and carefully assess your financial position and the risk with your attorney, accountant, or financial advisor. There is an inherent risk to writing a non-contingent offer. Only you, after careful consideration and deliberation with a qualified California real estate attorney, accountant, or financial advisor, can decide how much risk you are willing to take. It is your decision alone and cannot be made by your broker or real estate agents. Buyer acknowledges the buyer read, understand, and received a copy of this non-contingent offer advisory. Right? Good form, good information. All right. The other form that's new is going to be your solar advisory and questionnaire.
Amy, what was that last one called?
That is called the non-contingent offer advisory, the NCOA, NCOA. All right.
So
Solar.
I'm trying to bring up the, trying to add the form from the forms library for the solar advisory, and it's not coming up. Is there a trick to this one?
It's under solar, SOLAR.
SOLAR. That's what I'm typing, and nothing comes up. It says no options.
It came up in mine. I've got it open. I don't know why it's not coming up in yours. We'll have to look at that later.
Okay.
But because it's not coming up in yours, Anastasia, I will read the first page to you and some of the second page. Okay, solar ownership. I was going to do this anyways. Property address, date at the top. Solar ownership. Solar systems may be owned outright, owned with financing, owned with a lien or security interest on the real property or leased. Many property owners who believe that they own their solar system may not have free and clear ownership in that system. Wah, wah, wah. Ownership could be subject to a note or deed of trust issued when a solar system was financed or the UCC-1 financing statement filed with the California Secretary of State. Financing the solar system may also be secured in an assessment against real property. Please don't ever do that. That is collected through additional property tax payments for the period of financing. An example, a HERO or PACE loan. Because if somebody says HERO or PACE loan, run. Because the seller's property tax statement will reference the solar lien, sellers may not remember the lien or that it is secured by the real property or panels or other equipment attached to it. If the seller is intending for those private loans to be paid off as part of the sale, terms may be needed to be added to the agreement in this situation. Oh, good, Anastasia, I'm glad you got it. Solar liens with a power purchase agreement and solar leases. Many solar systems are not owned, but instead are leased. While the system typically has a fixed or scheduled monthly payment, other systems may have a power purchase agreement requiring the purchase of all or a portion of the solar power generated at an agreed contractual rate from the solar company with the ability to sell any excess energy to the electrical provider company, example PG&E, in accordance with the system's governing regulatory scheme. Payments under such arrangement can vary depending on the amount of energy created and used. Even solar systems that are leased may have security interest attached, such as a UCC-1 or fixed filing recorded in the county where the property is located. In some cases, the lender or lien holder for the solar system may allow the buyer to assume an existing loan and may agree to allow the solar lien to subordinate to or become secondary to a new purchase loan. However, in many cases, the holder of the security interest will not release the priority of its security interest, which means the solar loan must either be paid off when the property is sold or that buyer must purchase without obtaining new financing. When there is a solar lease, a buyer may be permitted to assume the terms of the solar lease, but only with the approval of the solar company. For lease systems, there may be a provision enabling the purchase of the solar equipment prior to the end of the lease term, or a provision allowing for the termination of the lease at cost with no retained ownership of the solar equipment, a buyout. There may also be a clause enabling the purchase of the equipment or the termination of the lease without any pre-agreed cost. In those cases, the cost will be an appraised value determination by the solar company. If a solar system is owned by the seller may have the right to remove the system and its components and install them on another property. If the system has been financed and the financing is secured by a lien on the property or the component parts, the seller should consult with the company about both the effect of the removal of the system or its components on the lien and the consequence of any damage caused by the removal. All parties are advised that the multiple listing service and other advertisements that are used to list and market a property for sale are not contractual agreements. Thus, it is imperative that the buyers of the property with a solar system, solar property, receive and carefully review copies of all documents, including any solar agreement, underlying security agreements for owned equipment, or any other material that the seller possesses prior to the buyer making any final decision regarding the solar system. Keep in mind that most solar systems too have a private transfer fee. You want to make sure you check that box in the purchase agreement. Buyers shall not simply rely on the information in the MLS or any other advertising material. 4 is purchase contract and transfer issues. The car purchase agreements include the contingency for review of leased and liened items and systems in order for the buyer to review any agreements or documents related to any solar system and to property evaluate all of its present and future terms and conditions, including the cost of accepting the existing solar system. The default language provides that the system is being transferred, and if the buyer has a contingency to determine whether the buyer is willing or able to assume the lease, lien, or other agreement. If the solar system is not intended to be transferred with the property, the contract may need to be modified to address this. If a leased or lien system is to be assumed by the buyer, the solar company may take steps to ensure its priority interest against the property, and or the buyer's lender may require a solar endorsement from the title company. If this occurs, escrow could be delayed. Buyers and sellers should be aware that because any buyout or assumption of a solar system could impact closing escrow, they should consider including a provision in the purchase agreement to allow for possible extension of the closing due to a due date to facilitate dealing with any problems that may arise because of the solar system. Solar evaluation, recommendation, and legal advice. Real estate brokers and their agents are not qualified to evaluate the terms, conditions, and the security interests of the solar system. They are also not qualified to determine the quality of the solar equipment or the impact of any regulatory scheme on an ownership or use of solar equipment. Buyers and sellers of solar property should consider retaining the services of a solar photovoltaic system inspector if one is available in the area where the property is located. Everybody go find some inspectors. Broker recommends that sellers and buyers of solar property exercise diligence in obtaining copies of any contracts, agreements, or other documentation related to any possible solar system security interest as soon as practical to enable a prompt evaluation of what may be required to facilitate the sale of the property. Additionally, obtaining a buyout or obtaining any agreement for a buyer to assume the solar agreement may take considerable time and or be of an uncertain cost. Therefore, the sellers of a solar property should, prior to entering into purchase agreement, determine if a buyout or a loan assumption is available and what cost and terms, so as to make a full and complete disclosure of the potential buyer to avoid any delays in the close of escrow. Whether or not a solar system inspector is used, buyers and sellers should consult with a qualified California real estate attorney prior to entering into any agreement to purchase or sell solar property. That attorney should evaluate the existing solar documentation and properly craft language to be included in the purchase agreement that would best protect the interests of their clients. Real estate brokers and their agents are allowed to prepare standard real estate transaction documents, but they're not qualified to create specialized contract language that may be needed to deal with specific issues involved in any specific solar property. Then it goes on for a solar property questionnaire, general solar system issues. This is going to need to be answered by your seller. You should not help them or advise them. If they mark yes to anything, an explanation is going to be required. Own solar system, if applicable, conveying with the property, right? Is there any balance on the financing? It's going to ask them questions. Leased solar systems or systems with a power purchase agreement, right? So leased or power purchase agreement, or we have owned even if they're financed on B. So you got B and C. Seller acknowledges that seller has read, understand, received a copy of the solar advisory and questionnaire, and the seller represents that the seller has provided the answers and if any explanations and comments on the form in any attached addendum, and such information is true and correct to the best of the seller's knowledge as of the date signed by the seller. And then the buyer acknowledges the buyer read, understand, and received a copy of the solar advisory and questionnaire. Solar. Any questions about the solar advisory and questionnaire? Car form solar.
So this non-contingent offer and the solar, you are recommending to for the to be put with the seller's packet, right?
The non-contingent offer advisory, I would put with
The
my
buyer.
buyer representation agreement, or any offer that the buyer makes if we didn't sign it with their buyer representation agreement. I want them to see it up front. So I would include that with my buyers. The solar advisory and questionnaire, I would include with any listing that has solar panels
Okay.
with my
And then
listing.
was there any
for that
other,
documentation? Sorry, what were you saying?
is there any other new ones that I missed?
There are, it's recorded, so you'll be able to come back and watch it, but the
Okay,
other new
I'll do
forms
that.
is the buyer representation and broker compensation agreement, which we covered in the last
Right.
session. We have our anticipated broker compensation disclosure, which is an important one that we covered this time. The buyer transactional advisory, which is part of the buyer representation and broker compensation agreement. So we didn't go into details with it this time. If you didn't include the BRBC, the buyer representation agreement, then you may want to include that buyer transactional advisory with your purchase agreement. Otherwise, it's already been covered. You have the cancellation of buyer representation. So there's a separate form to cancel the buyer representation now. You have your notice of identified properties in the instance they do cancel the representation. You have your seller payment to the buyer's broker if you're trying to negotiate your commissions to be covered, a gap in your commissions to be covered as part of the contract. You have a rental property owner disclosure, which may come into play with your RLAS. And then these two forms are the other new forms, the solar advisory and questionnaire and the non-contingent offer advisory.
Okay,
But I would include, anytime I make an offer on a property, I would include a copy of that seller's, no, I would include the anticipated broker compensation disclosure anytime I made an offer on a property, as well as this non-contingent offer advisory.
okay.
So those two
then-
go
and
with
then I'll go back to-
everyone. Oh, I'm sorry.
No, you're good.
Right. Yeah, Heather, I would include those with everyone or with the buyer transactional advisory and the non-contingent offer advisory could go out with your broker buyer representation and compensation agreement. They could just sign it once and be done, and then you wouldn't send it out again. But that buyer, the anticipated broker compensation, I would send out with each offer.
And that non-contingent form, that whole form is new?
That
Or
whole
no?
form is new, the non-contingent.
Yeah,
offer
because I
advisory.
think that's really good because I don't know that, I mean, you know me, I'm newer, but I don't know that that's written anywhere for people to understand, because I've been trying to tell my people that. And even last year when the market was way different, like don't like, you have an obligation to look out for yourself, kind of, you know what I
Yeah, and I
mean?
appreciate that this gives us the freedom to be able to say, hey, this is what people might be doing, but whether you decide to do it or not
Right.
is up to you, and it may help your offer get accepted, but we don't necessarily recommend this.
Right.
I
I think
appreciate
it's
that.
good. I think it's a good form. Yeah.
Yep.
I do. Thank you.
All right,
Amy.
any other questions before we sign off for the evening?
No, ma'am, sorry I was late.
It's okay. I'm
I-
just glad
I
that you guys
will-
attended so that I didn't have to teach myself the whole time. I had talked with Abby about potentially canceling it, and I said, it's all right, I'll just teach myself, and then everybody joined in, so I appreciate that.
And does
That's
she
funny.
put did she put the sign in on the chat?
I do not have the chat pulled up. Let's look and see.
Let's look, everyone.
No,
Oh, yes, she did.
there you
Okay.
go. It's like
All right.
magic.
Poof, Abby, you're the best.
Or log your attendance. And then I'll see you, I won't see you tomorrow for Rev Up, but I'll see you on Thursday where we go over the CMA process again and how to really dig into that Cloud CMA report and maybe some other features that you can do with Cloud CMA, because it's got some hidden features in there that are pretty cool.
And speaking of, check your email.
Okay, fabulous. I will check my email after I go feed the animals in the dark and the rain.
Go feed your
Oh
animals.
my goodness.
They have
Amy.
they have preference.
My
Yeah. it's nasty
my
outside.
son
But
my son and I said we have another way for you to make money, Amy. That you can be the person at the end of those like medical like things, and you could be like, all of these side effects are not my son was like, she'd be really good at that, because he was listening on the ride home from school.
That's funny.
So anyways, I was like, oh, Amy can like that, she can make some more money. Okay, bye Amy, thank you.
You're welcome. Have a fabulous evening, everyone. Thanks, Abby.
Bye. Night.